Hello, everybody. Welcome. Thank you so much for coming. My name is Beth Gardner, and I work for Carolina Public Humanities. On behalf of our whole organization, we are very glad that you're here. At Carolina Public Humanities, we do a lot of things, but generally, we curate opportunities for people to flex their curiosity and to talk to each other and to explore the complex constellation of subjects and questions that affect our daily lives. And we're lucky to have two powerhouse resources fueling our work. First, we have the humanities, which, as you know, offer powerful tools for reflection and for connection and for creative thinking. And we have UNC Chapel Hill. We get to build bridges between the people of North Carolina and the wealth of scholarship and expertise, and also the generous and interesting and fabulous human beings, like the folks to my left, who make UNC great. One of the best parts of my job is I get to sit at my desk and think, I wonder if people would want to have a conversation about the Supreme Court. And then I reach out to a number of distinguished scholars who I've never met before and ask, do you think you'd want to join us to do a thing about the Supreme Court? And they all say, yeah, absolutely. When do you need us? What are you thinking? And sure. And then we put the word out into the community, and I say, hey, community, would you like to talk about the Supreme Court with some people? And you say, yes, absolutely. You show up, and you put the public into the public humanities and let us do our job. We cannot do our job without you. And it makes all of this feel like community. So thank you once again for joining us and joining this conversation. And I would be remiss if I didn't talk about another powerhouse resource fueling this event, and that is the Chapel Hill Public Library. We love libraries at Carolina Public Humanities, and we love librarians, and we are so grateful to this library for partnering with us to present this event, and for saying yes when I called out of the blue and said, hey, do you want to do something about the Supreme Court? And we just think that they're so cool. So please show the library some love, make sure your library card is up to date, check out some books, and check out all the other amazing things they're doing. I will stop talking at you soon, and I would like to start our event by introducing our moderator, Ellie Campbell, who is a reference librarian and a clinical associate professor of law at UNC Chapel Hill. She teaches advanced legal research, and her research interests include critical legal research, legal information technologies, Southern legal history, and depictions of law in speculative fiction. Her most recent article, Critical Legal Research, Artificial Intelligence, and Systemic Racism, Teaching with Jim Crow Text Mining, won the Paul Gans Award from the American Association of Law Libraries. I'm going to stop talking and let Ellie take it away, and I'll be back at the very end helping you all be heard when you ask questions. But thank you all for coming, and Ellie, take it away.
All right. Well, good evening, everybody. Thanks very much to the Carolina Public Humanities for having us. Can everyone hear me? Great. So I'm going to give us a little intro and then introduce our speakers, and then we'll let them take it away. Our guiding question for the evening is, what do our panelists think is most important for North Carolinians to know about the Supreme Court? We hear about it so much in the news, recent cases that are handed down, ethical concerns, appointments process, but it's not always easy for us to understand what the court does and how it affects our lives. From our organizing discussions for this event today, I kind of pulled out three big topics that our panelists might address. So first is, of course, recent cases and ongoing issues addressed by the court. In the past few years, we've seen major cases on things like abortion, the Second Amendment, voting rights, the Chevron doctrine, and many more. And we might also anticipate things like First Amendment concerns with events like recent campus protests. Second, I think we might think broadly about the court and its work. So judicial appointments always make the news when there's a vacancy. We've got a lot of recent concerns about the court and its ethical obligations. And then also, what are the various ideologies that the court draws on when it's making its decisions? Third, we can consider how we understand the court. How does the media depict the court? Is this a helpful or accurate way of understanding its work? we might also think about the history of the court and how its role in nature has changed over time. So I think our structure for the evening is that I'll introduce one of our panelists. They'll have about 10 minutes for comments, and then we'll go to the next and the next, maybe about 10 minutes for response, and then Q&A, although, of course, we want this to be conversational. So if it turns into that, that's fine, too. So with all of these topics and concerns in mind, I will introduce our first panelist, Isaac Una. Isaac Una joined UNC in 1995 and is a professor of political science. His research and teaching interests focus on judicial institutions and their collective influence on public policy and bureaucratic behavior. His first book, The Courts of International Trade, Judicial Specialization, Expertise in Bureaucratic Policymaking, examines the role of specialized courts in U.S. trade policy implementation. In his second book, The Supreme Court in American Politics, uses an evolutionary perspective to give readers a firm understanding of the U.S. Supreme Court. Isaac?
All right. Thank you very much, Ellie. Can you guys hear me okay? I think I turned this thing on. Okay. So I am very, very excited to join you all today, and thanks for the invitation for us to talk about subject matter that is dear to my heart, which is the United States Supreme Court. In my opinion, when I tell this to my students, they think I'm joking, but I think the Supreme Court is an important station of power in American government. What I would like to do to start off with is basically to underscore what actually goes on in the selection process of Supreme Court justices. As you all know, whenever there is a vacancy in the U.S. Supreme Court, it is the responsibility of the President of the United States to actually nominate someone. Someone presumably is very well qualified, someone that the President perhaps knows, maybe sometimes they are appointing, but there is usually an underlying ideological consistency between the President and the person that they are nominating. All right. And one of the really most important things that I think citizens ought to understand about the selection process, the Supreme Court itself is, we know it as a legal institution, but the court is a big, big political institution, right? And that really starts with the process of selecting individuals to sit on the United States Supreme Court. And whenever there is a vacancy and the president nominates someone, there are always interest groups that go to work to try to find all kinds of dirt on that individual, to communicate to members of the Senate, to try to either scuffle or scuttle or prevent someone from being confirmed to the United States Supreme Court. So it's very important for citizens to know that, sure, we understand the Supreme Court as a legal institution because they are the premier exponent of the United States Constitution. They interpret the Constitution, they interpret statutes enacted by Congress. But it's very, very important for every citizen to understand and to really get this point that the Supreme Court is a political institution. Right, and this is what we teach our students, and the empirical research bears that out. So in 1990 or 1991, President George Herbert Walker Bush, the senior George Bush, nominated Clarence Thomas to the U.S. Supreme Court, and in his nomination introduction of Judge Thomas at that time, he was in the D.C. Circuit Court of Appeals, he said, I am nominating Clarence Thomas. He's the best person for the job. Okay, the best person for the job. And I think what President Bush was communicating at that particular instance is that in the Supreme Court, the individuals that we appoint to sit in the Supreme Court are the most qualified for that particular position. Right. But once again, that's not necessarily the case. There are lots of different motivations that go into a president actually nominating any particular individual to sit on the U.S. Supreme Court. It could be because of some policy motivation that the president has. They were trying to get someone on the U.S. Supreme Court who would actually support the policy agenda that the president has. In some other situations, it would be because the president knows this particular person, they like this person, they know their politics, they know that they're a good lawyer, and they think that person should sit on the U.S. Supreme Court, right? So there are lots of different reasons why a president might nominate someone to the Supreme Court. It's not necessarily the case that this is the best qualified person to sit on the U.S. Supreme Court at that particular time. And another thing is the ideology of the judge is incredibly important. And Republican presidents don't go out and nominate individuals that they're considered to be liberals, right? And progressive Democratic presidents don't go out and nominate someone that is considered to be on the far right, right? So presidents typically would appoint or nominate someone that they know would be ideologically consistent with that president's own beliefs about the interpretation of the Constitution, the way that public policy ought to work in the United States. So we're having a presidential election, and whoever becomes president would be in position to nominate someone, assuming that there is a vacancy, nominate someone to the U.S. Supreme Court. So these are some of the important considerations that the president would take into account when they send a particular name to the United States Senate for confirmation. All right. So I hope that you guys will have questions about the judicial selection process to the U.S. Supreme Court. I know that we have a lot to, so I would end there as this particular point is concerned. I want to just touch a little bit on the issue of ethics. So the Supreme Court has been in the news quite a bit over the past few years, with questions of ethics being raised about some individual justices, like Justice Clarence Thomas, Justice Samuel Alito, a few years ago, Justice Elena Kagan, Justice Antonin Scalia. They've all been involved in something where someone is questioning their impartiality when they make decisions, right? And so ethical questions have come up, and the American people are paying attention. For the longest time, American people didn't really question or care about what was going on in the U.S. Supreme Court. And so while there are some ethical canons that justices are supposed to abide by, people don't pay attention. And so what typically happens is that Supreme Court justices basically do whatever they want, right? But last year, Chief Justice John Roberts, I think working with the other justices, came up with a set of rules, right? And I say a set of rules in the sense that usually rules are binding and they are enforceable. But when it comes to the U.S. Supreme Court and all these different ethical standards that Chief Justice John Roberts and the rest of the justices came up with, that there is no enforcement. So even though they have a particular code to guide their behavior, so for example, if you have a conflict of interest in a case, you're not supposed to sit and decide that case, because the presumption is that you're not going to be fair in deciding the case. And one of the hallmarks of our justice system is that judges are supposed to be fair. You go to court, you spend money and hire a lawyer, with the intention of getting a reasonable, unbiased outcome for your case. And so if there is a question of bias a judge or a justice might hold, well, that really makes a travesty of our justice system. So ethical issues are incredibly important. I think the Supreme Court is, I guess I can in fact say it is on the right path. This new set of rules that have been kind of clarified by the Chief Justice But the one thing that we can, as citizens, we can still question about the Supreme Court and the justices as far as ethics are concerned is that there is no enforcement mechanism. So the justices, once again, can either choose to sit on a case, even though they might have a potential conflict of interest in that case, and no one is going to say anything because the justices themselves are responsible for recusing themselves if they think there is the potential that someone might question their impartiality, right? It's like, a little child guarding the cookie jar, right? So there's no enforcement mechanism for a recusal behavior in the U.S. Supreme Court. And I was looking at the rules that Chief Justice John Roberts put forth, and one of the rule is that the necessity of a justice to sit and decide a case supersedes whatever conflict would make that justice to recuse himself or herself from a case. And I read that, I said, wow, that does not seem right. But that is part of what is going on. Okay. I want to touch very, very briefly. 2 minutes. 2 minutes. Okay. I would be remiss if I don't talk a little bit about the Second Amendment. You are all going to hear a lot about the Second Amendment in this presidential election speeches that are being made by the various candidates. The Supreme Court a few years ago decided the case of Washington, D.C. versus Heller, where the justices said that the Second Amendment to the Constitution bestows an individual right to own firearm. Now, I think a lot of Americans have accepted that interpretation, but I happen to think, and I think there's a lot of people that would agree, that that interpretation is actually incorrect. Because if you read the Second Amendment, and if you want to know what it says, I've got the Constitution right here. If you read the Second Amendment to the Constitution, it says a well-regulated militia being necessary for the defense of a free state, the right of the people to keep and bear arms shall not be infringed. That's the whole 21 words in the Second Amendment, right? But it's like we completely forgot about the first part of that amendment that says a well-regulated militia. I don't know if there are any English major English experts here, but it seems to me that that second part of the Second Amendment that says the right to keep and bear arms shall not be infringed, that is contingent upon there being a well-regulated militia, right? But anyway, this is something that I'm sure that some people realize, but I think a lot of people don't know. Maybe they have not actually read the Second Amendment. But I think there is a very, very strong misinterpretation of that amendment. And this position is also a position that was taken by former Chief Justice Warren Burger. Okay, the Chief Justice appointed by Richard Nixon said that interpretation of the Second Amendment as bestowing an individual right is the biggest hoax that has been perpetrated on the American people, right? So anyway, I think I'll stop there and give my friends, there's a lot more I can say, but anyway.
Well, we will have plenty of time for discussion. So thank you so much, Isaac. Our next panelist is Michael Gerhardt. Michael joined Carolina Law in 2005 and serves as the Burton Craige Distinguished Professor of Jurisprudence. His teaching and research focus on constitutional conflicts between presidents and Congress. And he is the author of 9 books, including the recent Lincoln's Mentors, The Education of a Leader, and 2 forthcoming volumes, FDR's Mentors, Navigating the Path to Presidential Greatness, and The Law of Presidential Impeachment. So, Michael?
Thank you. In fact, I want to begin with both thanks and because I'm a lawyer, lots of disclaimers, which should pretty much eat all of my time, if I've calculated it correctly. Now, first and most importantly, I'm grateful for the opportunity to be here, to be educated by both Isaac and Kevin, or at least Isaac, I should say. No, he's my neighbor. I've got to, yeah, I got to tease him. And actually, an opportunity to speak to all of you about something that is extremely important. A couple disclaimers as I do that, or before I do that. One is I have looked at the Supreme Court from a number of different perspectives. I have studied it as a scholar. I've written a couple books about Supreme Court appointments and a number of sort of, I guess what we'll call academic articles as well as op-eds about the Supreme Court. And I've tried in doing that to be an educator, to sort of inform people about what I think is important about the court, why they should care about it, and how whatever the issue is I'm writing about should concern everybody, and hopefully how it gets resolved. Second, however, I've also participated from 2009 to 2021 as the special counsel to the Senate Judiciary Committee for 6 Supreme Court nominations. So I've taken many leaves from the law school to go do that. And that has given me a great perspective of what's happening inside the process. I can talk about that a little bit, but as you probably can tell, there's only so much I can share with you from that experience. And then the other perspective I have, which is of complete irrelevance ultimately, is that I'm a citizen too. Yeah, and I vote and I participate in the political life of this country, and therefore it's not for me a game, and it's not for me an academic enterprise, just purely academic enterprise. This is our world. We need to understand what's going on in that world. So whatever I share with you will be probably shaped by those different things, and hopefully it'll be informative. I want to begin, therefore, with what I perceive to be different perceptions of the Supreme Court. Think about it in this way. Why is the Supreme Court important? Why do we care about it? What's its function? And I think what we discover is that there's a lot of disagreement about all of that, which is actually rather striking. Because you would think there ought to be consensus on, okay, what is it the court does? Again, why does it matter? And I'll show you how that can play out. If I'm looking at this purely as a legal scholar, I'm thinking of the court as really 9 lawyers who are going to look at legal materials to help them figure out how to decide a case or controversy that has come to the court. So it primarily consists of, one would think, legal reasoning. And legal reasoning basically comes down to reasoning by analogy. And so that's one way to look at it. I have come to the conclusion that's a rather naive way of looking at it. Because, as Isaac points out, and his experience suggests, the Supreme Court is politically elected. And as such, it is different than any other court in the United States. It is unique. In fact, they'll tell you that. They'll tell you they're unique. They'll tell you they're so unique, they therefore don't need a code of ethics. When I was working in the Senate, one of the things we oftentimes were trying to figure out is how do we get a code of ethics implemented through law? We all were aware that if Congress did anything, it would likely be struck down by the court. By the way, what does that tell you? And so one of the things you discover rather quickly is, first, the Supreme Court is not politically accountable. Secondly, it's increasingly not accountable. That's one of the big changes I think that's occurred over time. I think a third thing is it's not as powerful as we think it is. Now, that doesn't mean we should close up our tents and go home, not worry about anything. But it shouldn't distract us from the fact that other constitutional actors make even more monumental decisions about the Constitution than the Supreme Court. The Supreme Court these days makes about 80 some odd decisions. That's a fraction of the constitutional decisions that members of Congress make. It's a fraction of the constitutional decisions the president is expected to make. And guess what? Presidents and senators make the critical political decisions to construct the court. So in a presidential election year, the thing you ought to care about most, if you care about the Supreme Court, is who you're going to vote for. Because that is going to shape the composition and direction of the Supreme Court. How do I know that? That's the history of the United States. All you have to do is go back to George Washington, work your way up to the present. Every president understands that shaping the Supreme Court has oftentimes enduring consequences for the country. So they care about it. And there have been fights over the Supreme Court that have been as nasty as any of we see today from the beginning of the Republic to the present. There's nothing new about the fact that the fights over the Supreme Court and fights over the vacancies, who fills them, are extremely important. Everybody in Washington gets that. Not a secret. It is an extremely nasty environment. My favorite time after having served in Washington is to see it in my rearview mirror. I do my service, and then I go home and hide. But one of the things we discover is that people inside the process actually end up looking at the Supreme Court very differently than people from the outside look at the Supreme Court. I think the American people largely, and I really would be curious both from Isaac and Kevin as to what the data might tell us, but I'm gathering that most Americans think of the Supreme Court as apolitical. In a sense, sort of, when I say above the law, I mean not literally above the law, although it's really not politically accountable. But what I mean is they're not supposed to be partisan. And they're supposed to be making legal or judicial decisions. They're not supposed to be making decisions about appropriations or do we go to war, things like that. It's a narrow function to decide a case of controversy. It could be an important case of controversy, Dred Scott, for example, or Roe v. Wade. But it's still a fairly narrow issue, but it could have significant consequences. But I think for most Americans, the court is a kind of mythic place. Oh, well, once you get there, whatever your partisan background is, it just kind of fades away, and you become this, this judge who's going to pay attention to legal materials and disregard all the partisan fanfare and make judicious decisions. Inside the process, everybody understands a lot of what Isaac was just saying, which is that different people will have different ideological commitments. And what matters most when we use the phrase best qualified, as far as the Supreme Court is concerned, that usually means ideology. It doesn't mean, graduating top of their class or having argued thousands of cases in the Supreme Court or whatever. It means, do they have the right ideology? And much of American history has been about refining the selection criteria to ensure that the justices who get appointed will have commitments which will stick and be enduring. So, long story short, on the nomination side, there's lots of fighting that goes on because a lot of people are fighting over the criteria, and they're also fighting over who best fits the criteria. They're also fighting about, okay, what is it exactly we want this person to do? We all know we want them to overrule Roe. What else do we want them to do? But beyond that, there are, and of course, with the confirmation process, that isn't the place where interest groups first get involved. In fact, let's be clear about this. Anytime you see a vacancy on the Supreme Court, that's oftentimes the end of a story. It's not the beginning of a story, because there's been tremendous amount of positioning and money that has been spent in preparing for that moment. So for example, when I was working on the Brett Kavanaugh hearings, I'm still recovering, I saw Stephen Colbert, a great constitutional law guy, say, no, we started this process with the Senate divided 51-49, and the vote ended up being 51-49. Millions and millions and millions of dollars are spent to change nothing. So think about that. Well, a lot of interest groups see this as a chance to raise money. A lot of interest groups see this as a chance to vindicate themselves. A lot of interest groups see this as a chance to be heard. And this is their chance, they think, to sort of protect the court, or to ensure the court's going to be the kind of court they want it to be. Which, by the way, tells us something about what the people who are appointed are as judges. Because people are betting lots of money at the front end. We can predict exactly what these people are going to do. And we're only going to predict the people, we're only going to pick the people who actually will vote the way we want. So inside the process, there's a great deal of real politics, great deal of awareness of, okay, we understand what's gone into this. We understand what the stakes are. For example, when I sat down with one senator, I won't say who, early on, the first question he asked me was, why should I care about this nomination? It's a great question. And I was at the other end of a table and I said, well, do you care about Roe versus Wade? He said, yeah. I said, then you should care about this nomination, because the president's going to appoint somebody that's going to vote to overrule Roe versus Wade. And he said, okay, you got my attention. Yeah. And so, to wrap this up, I just want to flag a couple things that are going to be important over the next several weeks and for the election. Yes, the election is going to have tremendous consequences for democracy and tremendous consequences for the Supreme Court. There's no doubt about that. Don't kid yourselves. Those things are on the table. But at the same time, we can't ignore that over time, the Supreme Court has grown more powerful and less accountable. So the big question for me is, how do we fix that? Because in this country, as far as I'm concerned, no one that wields power should either be above the law or unaccountable. And that's our challenge.
All right. Thank you so much, Michael. And so we'll move along to our third panelist. Kevin T. McGuire joined UNC in 2009 and is a professor of political science. His current research interests include the effect of the court's institutional arrangements on the court's policymaking, the impact of public opinion on the court, and the measurement and modeling of judicial outcomes. He's the author of Understanding the U.S. Supreme Court and the Supreme Court Bar, Legal Elites in the Washington Community, an editor, co-editor of a number of volumes, including Creating Constitutional Change and New Directions in Judicial Politics. Kevin?
Thank you, and thanks for coming out. I'm happy to be here with you and have a chance to talk for a couple of minutes. I would sort of echo much of what Isaac and Michael said, and I'm going to offer some sort of additional observations, maybe in a different direction. Start by saying one of the points that struck me I hadn't intended to mention, but I think it's important to draw out, is that Michael was saying how unique the Supreme Court is. And part of what makes it so unique is its discretionary agenda. And so it doesn't have to hear virtually any cases. And if the Supreme Court, imagine a world where it had to hear every case that was brought to it, it would look a lot like any other court that we're familiar with, because it would probably say what the court whose decision it's being asked to review said, which is, there's no problem here. What makes it so special is that it ends up taking cases where it's not clear what the correct answer is. So if you read Supreme Court briefs, they're right available online, anybody can look at them. You'll read the brief on one side, and you'll say, well, this is absolutely right. how could anyone come to a different decision? And then you read the brief on the other side and you say, well, that's right too. And so I think part of what makes the court so special is that it's seeing that small number of important cases where the answer isn't clear. There's no obvious legal rule that guides you one way or the other. And if I were on the Supreme Court and I didn't know what the correct answer was, what I would do, I'd do what those people do. I'd make the decision that I thought was in the best interest of the country, which is to say I'd follow my political ideology. So that's why they're able to be in a unique position, because there isn't an obvious correct answer to most cases. What else would you base your decision on? Okay, I want to say a few things about how I think we should view the Supreme Court in a kind of sort of general political context. In other words, how seriously should we take what the court does? Should we celebrate decisions that we agree with? Should we be up nights worrying about decisions that we disagree with? And a lot of people do that, and I watch the same television programs and read the same newspapers that you do. I see lots of hair on fire. I see lots of people that tell me that the Supreme Court is ruling our lives, and it tells me a lot about why I should be so concerned about these 9 unelected individuals governing all aspects of our daily existence. I think that notion, it's certainly true to a certain extent, but I think it's oversold. I don't think the Supreme Court is quite as important or quite as deviant from what the public expects as we might imagine. And so I want to talk briefly about a couple of issues. One is, she mentioned earlier, public opinion in the Supreme Court, and then a little bit about what the court's consequences are. In terms of public opinion, if we take cases, if we ask people, tell me an important Supreme Court decision, I ask my students all the time, and they always mention 2 cases, probably the same 2 you would mention. Roe versus Wade and Brown versus Board of Education. So let's take Roe for a minute and ask ourselves, did the Supreme Court really reach out and do something that was that unusual by establishing a constitutional right to abortion? Well, legally, I suppose it did, but if you look at what was happening in the states leading up to Roe, states were actually liberalizing their laws in the years leading up to 1973. So, in fact, what the court did was kind of put its imprimatur on a kind of shift in public view towards allowing women greater freedom to make those sorts of reproductive choices. It wasn't so much going against the public view as it was sort of following it. More recently, I think we could look at a case like Obergefell versus Hodges, which is the same-sex marriage case. And you might say, well, the Supreme Court really did something radical by establishing that the Equal Protection Clause ensures that individuals, regardless of whether they wish to marry a person of a different gender or the same gender, it's protected by the Constitution. Well, if you look at the data, you see that states had been, just as in the case of Roe, liberalizing their laws and allowing for same-sex marriage leading up to that decision. In fact, by the time the court made its decision, most Americans were living in states that allowed same-sex marriage. So it had already been moving in that direction. Doesn't mean that that decision is unimportant any more than it means that Roe is unimportant. It's sort of a question of how we should view those decisions. Are they making decisions that are radically out of step, important decisions that are radically out of step, or are they kind of following the leader? And I would say it's not a perfect relationship, but usually I think we might see the court kind of following what it is that the public policies are generally, what public opinion is generally drifting towards. Okay, now say a little bit about, does the court matter? Michael was saying the court is important, but maybe it's oversold. I'd take that a bit, maybe I'd take that a step further. Say the court, while it is important, doesn't matter nearly as much as we imagine it does. It makes decisions. We think that those decisions are immediately put into effect. That's not necessarily the case. The court makes decisions, and sometimes there's resistance. You see in various places around the country, you can take older examples like school prayer, where folks continued to pray in schools even after the court said that was no longer permissible. But if you take a decision like the Brown decision, everyone imagined that schools immediately desegregated in 1955. Well, that didn't happen. It didn't happen in 1955 or 56 or 57 or 58. If you look at the data, the number of black school children going to school with whites was 0, or close to it, for about 10 years. And then all of a sudden it started to change. You saw integration. Why? Did people suddenly say, I must have overlooked on this big stack of papers this Supreme Court decision? No, Congress passed the Civil Rights Act and said, look, you're not desegregating. We give you a lot of money to fund educational programs. If you want to get that money that we give you, you're going to have to comply with the decision. So Congress got involved and it made that happen as much as the Supreme Court did. Two other examples I'll give quickly. The Supreme Court, in a case that originated here and at Harvard, the case of affirmative action. The court had long sort of held that in various degrees, state institutions were permitted to take race into account in making admission decisions. And I read the newspaper, and it tells me that the diversity of American education is in dire straits now as a consequence, that this can no longer be considered. Well, it depends on how you look at it. And the way I look at it is to suggest that most schools don't use race as a factor because most schools admit virtually everybody who applies. There are about 15 million undergraduates in the United States, and they go to about 3,200 schools. Of those schools, about 70 to 80% basically let anybody in. Right? They do have standards, obviously. I went to one of those schools where I think the only qualification was whether you could walk erect. So I'm one of those people that went to a school that didn't really make that type of decision. And most schools are like that. Most schools are not what we'd say is competitive. And so they don't need to factor in race as a kind of tie-breaking factor. Who needs it? Competitive schools. Schools where you're looking to differentiate between people that look very much alike. And we say, well, how do we distinguish this applicant from that? You could give a benefit to race, which the court said you could do for a long time. Now, how many schools practice that type? How many people need to use race as a factor? About 68. There's 68 schools that admit less than 25% of their applicants. That's 2% of all colleges and universities. And they educate less than 500,000 students, or about 3% of all the students. We could eliminate every competitive university today, and all the students would be readily absorbed into other institutions. There's just not that many schools where race is an important factor. And so while we certainly should care what the court says on this issue, I'm thinking about, well, what difference does it make? And my view is that it's an important policy, but the consequences are not nearly so drastic as we're led to believe when we look at the newspaper or watch television. Now, I'm not suggesting the court isn't important, I'm just saying we should view it with a broader lens. And when we look at it in that way, I think we might temper our outrage or enthusiasm, as the case might be. Last case I'll mention is the issue of presidential immunity. I'm sure you're familiar with that decision decided just a few months ago about presidents having immunity for their official actions. Is that a radical idea? Not terribly. Congress has immunity for their official actions through something called the Speech or Debate Clause. The court had previously acknowledged presidential immunity from civil lawsuit. So it's not crazy to say that presidents have immunity from their official actions. But I want to think about, well, what's the difference? The difference is I'm not sure that many presidents go around trying to break the law. most presidents are kind of constrained by other factors. They like public approval, they like earning the respect of others, they like having support in Congress, they are motivated by a desire to be remembered favorably by history. I'm not sure all presidents fit into that category, but typically that's what presidents do. So even though presidents now presumably have the right to violate the law when they are engaged in official acts, I'm sure that many are going to be going around doing it. And so it doesn't mean that it's not important or that we shouldn't pay attention to it, but in terms of its broad consequences, I think it's going to be pretty minimal. So the last thing I'll say is just by way of summary, and that is, should we pay attention to the court? Naturally, of course we should. We should pay attention to it no more or less than we do other institutions, both the federal and at the state level. But I'm not sure that we should magnify this, the decisions of the Supreme Court, especially when we disagree with it. I mean, the court makes decisions I don't agree with. Just to give you one example that I think was the wrong decision, the price of your pork chops will be going up thanks to a decision the Supreme Court made last term having to do with an obscure area called preemption that falls under the Commerce Clause. But most of what the court does is actually pretty boring. And for the most part, the decisions the court makes don't matter much in our daily lives. And I'm not saying that it's a bad thing necessarily. I would be worried if I thought the Supreme Court was deciding case after case in ways that govern my life. But they decide an awful lot of boring cases that don't really matter much. They matter to the institutions, organizations, and corporations and state governments that are involved. But they don't really govern our daily lives in the way that one might be led to believe if we based our analysis just on what we see on television and in the newspaper.
All right, thank you so much, Kevin. So we now have about 10 minutes, maybe 15, for general discussion on the panel. I want to briefly bring us back to our guiding question for the evening, which is, what do we think is the most important thing for North Carolinians to know about the Supreme Court? But beyond that, does anyone want to respond to anyone else's comments to start us off? And if not, I have a couple questions.
Well, there was one item that I wanted to mention that I didn't mention. The court this year recently decided a case where they overturned a 40-year precedent, legal precedent, for the Chevron doctrine. I don't know if you guys have heard about it. This was the original case, Chevron versus Natural Resources Defense Council, was a case decided during the Reagan administration in 1984. And the Chevron doctrine basically says that, Congress enacts statutes, and those statutes are going to be interpreted and implemented and enforced by the bureaucracies, the executive branch. And so when there is a conflict about the interpretation of that statute, somebody might sue the agency that is responsible for the implementation of the law, and the case will go to the court, eventually to the U.S. Supreme Court. So when in 1984, the Supreme Court got this case, the justices ruled that when the statute is clear about what the intent of Congress is, then that is the end of the matter, okay? So if the agency interprets the law in a way that is inconsistent with the intent of Congress, then courts can rightly overrule what the agency has decided, right? But in situations where the law is not clear, where there is ambiguity, where maybe an important issue was omitted by Congress in the drafting of the legislation, when it comes to situations like that, then the courts have to defer to the interpretation given by the bureaucrats, by the agencies, right? So that was the rule governing how our federal government operated since 1984 to the present time. And very recently, just a few weeks ago, the Roberts Court overturned that decision. And one thing I should mention is that we always think about Ronald Reagan as this, obviously he was a great president, but one of the defining characteristics of the Reagan administration is that it was an administration that ushered in small government, right? But then they got this really important decision in the US Supreme Court that ended up expanding the administrative state, expanding the federal government, right? This actually happened during the Reagan administration, all right, which is kind of inconsistent with the way that we think about Ronald Reagan, all right, as the architect of small government. So I think the American people should be aware of what the Roberts Court has done recently, which is basically to overturn this really, really important legal precedent, so that now when any federal agency interprets a congressional statute and the case goes to court, the court now is saying that they would be the one to actually interpret the statute, not the bureaucracy. The court is no longer going to be deferring to the expertise and the interpretation given by those agencies to what Congress is trying to achieve. The court would now have to take it upon itself to do that. So basically, we are going to be seeing a significant judicialization of the federal government. That is what is going to happen. And so this case is going to be a boon to a lot of lawyers in the United States. So I just thought you guys should be aware of that. It's something that happened fairly recently. And I don't know how it is going to change the country, but I think this is a pretty big decision.
I'm debating. Let me just map on two other things to our discussion of the court, particularly things that people might want to be concerned about or might want to know about. One of them is something you're probably already familiar with, and that is the political rhetoric around Supreme Court nominations. It's, generally speaking, its language was designed to have a lot of winks and nods, signals, things like that, that basically indicate where a particular nominee would take the court without having to say so in so many words. Let me give you just a couple examples I'm sure you're all familiar with. Justice who's nominated to be in the mold of Antonin Scalia, who, by the way, is my constitutional law professor. And so, well, that pretty much tells you a lot, because you know what, he was on the court for basically 30 years. So you know he voted for 30 years. So if somebody's saying that's what they want and that's what they have, then you pretty much don't need to ask them questions like, what will you do about Roe? What will you do about the Second Amendment? What will you do about X or Y? Because you already know it from the record of Antonin Scalia. Second thing, let's find justices that will follow original meaning. Very popular, particularly since the 1960s. That in itself tells you something. Original meaning wasn't really all that popular. People were not griping about it, for example, in the 19th century. Not when, for example, Roger Taney in the Dred Scott case relied on original meaning to disenfranchise African Americans throughout the entire United States and turn them basically into property. And so why then talk about original meaning? Because it signals something. If somebody says, I'm going to follow original meaning, then you could probably figure out, oh, they're not going to like Roe versus Wade because I can't possibly conceive that the people who wrote the amendment had abortion in mind. So again, it's a shorthand. And much of constitutional law is learning about the language. And what we've got to think about is the political marketplace. And there's this rhetoric that goes on that is mostly designed to speak to sort of inside players. And ultimately, I think, does not inform the public very much about what's happening. The second thing I just want to mention really, really fast is that all of us here can figure out very quickly what issues matter with Supreme Court nominations. And that's because they've always been the same issues. We could almost say them together. One of them would be race. One of them would be criminal procedure, religion, privacy, national security. That's pretty much the ball game. And everything else, I think Second Amendment kind of fits into the security thing. Everything else it might be important, but it's not the kind of thing that people go to war over. And what do we discover? Those areas I just mentioned are the most fluctuating in constitutional law. Those are the areas where there's the most sort of instability, if you will. So whatever happens in this next election, we can pretty much ensure that these areas will continue to fluctuate no matter who gets elected. And that will probably persist. What I would hope, just to wrap everything else up, is I hope Isaac is successful and right, that I think a code of ethics is the least we can do for the Supreme Court. Because otherwise the Supreme Court becomes a safe harbor for people that are unethical. People that were sitting judges before they became Supreme Court justices were operating under codes of judicial conduct. Getting on the court allows them to get out from under that code. And that is not a good thing for the rule of law, which I just want to reemphasize is what the Constitution was all about.
I'll just say a couple things very quickly. First of all, to your question, why should North Carolinians, or how does it matter to them, the Supreme Court, what should you do? It's obvious. You should vote, and you should pay particular attention to your candidates for president, U.S. Senate, and then not just there, but for local officials, state legislatures, especially in the State House, because they're the ones that are probably going to be making policies in light of what the court says one can or cannot do. So I wouldn't discount the importance of your more local representation, because they're sort of the folks that will be making the practical decisions that are likely to affect your life. One thing I'll say very quickly, just because Michael mentioned it and made me think of it, is that Supreme Court confirmations have changed a lot in terms of the basis for the decision. If we look across the 20th century, in the early part of the 20th century, if you were nominated, you were probably qualified and you were probably going to be confirmed. We have nominees that are confirmed even without a voice vote. Right, so they just sort of say how many, and people just sort of shout it out. It wasn't that hard to be confirmed. And then you have a kind of middle period, maybe from the 1930s up until 2005, where it was a kind of mix of qualifications and ideological compatibility. And so you could almost always get someone in the Senate who agreed with you to support you, no matter what your qualifications were. But if you were well qualified, you probably got any senator's support, regardless of whether they disagreed with you. So both of those factors mattered. But since 2005, you can look at these data in a number of different ways. Qualifications simply don't matter anymore. That doesn't mean that presidents don't nominate qualified people. It just means that in the past, being qualified would have earned you the support of most senators. Now decisions are made almost exclusively on ideology. It's a really kind of interesting change to see historically how those two factors have evolved in their importance.
Kevin hopefully will forgive me, because I'm now going to play a little bit of a devil's advocate. So even before that period of time, before 1930, 1 in 4 Supreme Court nominations would fail. Why would they fail? Largely because of ideology. The first nominee to the Supreme Court rejected in the 20th century was here in North Carolina, John Parker. And he failed largely for ideological reasons. But don't believe me, believe George Washington, whose nomination of John Rutledge as Chief Justice was rejected because Rutledge had become unpopular with the Federalist Society, that's good, with the Federalist Party. No Freudian slip there. No. And the Federalist Party got even. Now, the thing about all that is Rutledge was probably perfectly well qualified. And I know you know this, but even within the time period before 2005, one of the very best qualified people in the country who got rejected was Robert Bork. And the reason, of course, was ideology.
Let me just add that when Rutledge was rejected, he got so depressed, he tried to drown himself in the river in the South. He was from South Carolina, I think.
Right.
He tried to drown himself because he was so damn depressed. Very interesting. But anyway.
Which reinforced the idea that maybe he was mentally unstable. It's like one of those things. Did we think that before he tried to kill himself, or did we think? Yeah. He was not successful.
The question back there.
Yeah, well, I think that brings us to our Q&A portion of the evening. I think we'll start with the lady in the back in the black t-shirt.
Thank you all for your remarks. I think your remarks were supposed to be sort of reassuring that things weren't as terrible as we don't think they are, but it does, you know, the woman in Georgia who's been in the news a lot lately. I mean, it does seem like people are literally dying from.
Yes, I wasn't trying to be reassuring. I understand why you might take it that way. It was more a way of saying, if you think things are bad, they're not as bad as you think they are.
But may I just want to add a wrinkle to that because that's what I'm paid for. No. No, one of the things that occurs to me is something that we're all familiar with. And that is when we're talking about making the Supreme Court, how the Supreme Court is politically constructed. Presidents oftentimes, working with senators and interest groups and others, have a relatively narrow horizon of the kinds of issues that matter to them. And one of the things to watch for and look at has to do with the issues that they didn't predict, or the issues that weren't really resolved by the focus on, let's say, original meaning, or by the focus on, let's get Roe versus Wade overruled. And Dobbs, which overruled Roe versus Wade, is a great example of that, because it raised questions which I think the Trump nominees, among others, didn't really think about ahead of time. Things like, well, can we mail an abortion pill? Things like, well, if you've got a law that dissuades people from saving somebody's life, is there a legal problem with that? Because people are dying. And I'm pretty sure that's not what they wanted. And so I think that, so one of the things that's also a hallmark of American history is you discover over time that, well, while people are able to reshape the court, like Franklin Roosevelt did, within about a decade or two after that, the court starts confronting issues Roosevelt never even thought about. And those nominees that he put there start to fracture over things like criminal procedure, incorporation, which has to do with applying the 14th Amendment to the states. So that's the other thing that's going on in this when we talk about the Supreme Court.
All right, I think I saw this gentleman in the aisle here had his hand up earlier, and then we'll just keep going.
As I move, I'm going to remind our audience online that you're able to also ask questions using the Q&A button at the bottom of your screen, and Paul will raise his hand in the back if he sees questions online and can read them. This is James, Jonathan. All right.
Regarding the Second Amendment, what would prevent Governor Shapiro from deputizing everybody in North Carolina to a militia and then regulating them?
And then doing what?
And then regulating them. And regarding the Constitution, I wonder if you could talk a bit about we think about the separation of powers, the legislative and the judicial departments, but what about the legislative component of judicial decisions, since every decision, in fact, is unique and further defines any law? right? There's a legislative component. I wonder if you could address that.
First, the militia. You always be the militia. So I think you mentioned Governor Shapiro.
Governor Stein's one we were thinking of.
That's right. I thought maybe he was from Pennsylvania. Well, I mean, I think that with the original conceptualization of the Second Amendment, okay, the governor should be able to do that, right? Should be able to say, well, I'm going to put in place a policy that I think will be consistent with the letter of the Second Amendment as it appears in the Constitution of the United States, right? And so the amendment says that there should be a militia. And I mean, obviously the governor alone cannot do this. It has to be along with the legislature. The legislature has to sort of put policy in place or enact a statute that would make this happen. But I mean, if a Governor Stein or a Governor Shapiro, to use your first example, were to do that, it would be within that governor's power, maybe even interest to do so. Because doing that would actually comport with what the Constitution says. Right now in the United States, it's like we have all forgotten about that first part of the Constitution, which is really, I mean, I call it the dependency clause, right? Whatever comes later, it's supposed to be contingent upon that first part. But that is something that I think, thanks to the National Rifle Association that have been agitating for this different interpretations since the 1930s, you know, they eventually have gotten their wish. I mean, I think everyone here should know that back in 1939, the United States Supreme Court decided a case, you can look it up, the case of Miller versus United States, where the justices, people like Louis Brandeis, Oliver Wendell Holmes, those big, large legal titans of American history, they were on the court at that time. And they decided unanimously, the opinion was 9-0, that the Constitution and the Second Amendment bestows a group right, not an individual right. But it was during that time that the National Rifle Association started plotting to change the interpretation of that Second Amendment to where we are today, right? So I didn't mean to go on and on and on, but that would be my response to your first question.
James?
So I am kind of piggybacking off. I mean, I think the notion that the court's decisions aren't that harmful or is less harmful than we think, I don't buy that. And I say that because I mean, we know what decisions they've rendered in the past. I mean, Michael, you mentioned various categories and constant fluctuation. One area where they didn't fluctuate for 150 years was on race. They would twist themselves in knots, and this notion that most of the decisions, there's no clear right and wrong answer, number of cases where there were right and wrong answers, and decisions are made to go in another direction. And I'm concerned about the current composition of the court and their mindset because of the Heritage Foundation and the role that it has played in staffing this team with people who generally are not that enthused about civil and human rights. And I think down the pike, we're going to see more harm coming from this court. I think they've just gotten started unless there's some change down the pike.
I mean, I think, I agree with almost everything you said. I think that, so when I think of those fluctuations, I'm thinking roughly within the last 100 years. But that doesn't negate the fact that race was also a really big factor in Supreme Court nominations up until the 20th century. Nathan Clifford, name everybody here remembers, had the closest vote in the confirmation hearing. He was nominated roughly in the middle of the 19th century of any person in history until later you get to Clarence Thomas and Kavanaugh. And what was the issue? Slavery. And this is because presidents and senators tend not to be politically naive. And they tend to understand that whatever the issues are, as de Tocqueville suggested in Democracy in America, they're going to make their way eventually to the Supreme Court. So what presidents and senators didn't figure out is, okay, let's stack the court so when the issue gets there, it'll come up with the answer we want them to come up with. That tells us a lot about the court. It also tells us a lot about life tenure, which is one of the features of being a Supreme Court justice, and why I think there's a growing consensus that was a really bad idea. But that's a talk for another day. Yeah.
We do have a question online, and someone asks, how important is 9 justices? Would 11 or 13 or 15 work about as well?
0 is my optimum. Well, 9 is a historical sort of accident, really. The court started off with like 6, and then turned out Congress, by the way, controls the size of the court, and they figured out, gosh, 6 can divide into 3 and 3. Oh, that's not too smart, is it? Okay. So then they started thinking about odd numbers. But to fast forward, when we get to the 19th century, what happens is Congress is beginning to shrink and expand the size of the court depending upon who's president. When Andrew Johnson's president, they basically try to shrink it. When Grant becomes president, then they re-expand it. So and they did that in 1869. Congress did that in 1869, settling on 9. So 9 is just a number that was historically convenient at that time. I think it's constitutional and permissible for Congress to expand it or even shrink it if Congress chose to do that. I don't think it's a hard constitutional issue. It's a political issue. Simply, is there political will to do that? I don't see it.
And can I just add, I would have thought this was unlikely before it happened, but I think it can formally change the size of the Supreme Court, but informally it can change the size of the Supreme Court. And I'm thinking of Senator McConnell's decision to hold up the nomination saying, until we have an election. I mean, you could make an argument that that effectively reduced the size of the Supreme Court from 9 to 8, at least temporarily. But I wouldn't have thought that that would have been the case. But I think we have to accept that that's a possibility now.
All right, the gentleman named Gray in the second row here.
Thank you. Could you kindly enlighten us about, and I agree with this gentleman here, there are many decisions they make are not that important to us, but a few, and I'm reminded particularly of the Roberts Court, and especially Chief Justice Roberts' vote that really allowed money to be the same as speech. Now, the impact of that was not on the court or on us, it was on the Congress. And suddenly the Congress is in an arms war every week about raising money. And they are, as we hear now, that they can't spend much more than 2 or 3 days in Washington working because the obligations to money. And we have now created a election industry.
Well, I would just say briefly that I think Citizens United, the case you're referring to, is a good example of a Supreme Court decision that has made a difference on the ground. And the difference it's made on the ground is because of all the money that's now being spent, which is virtually really difficult to regulate under the existing law. And therefore, almost anything goes. And what we end up with is chaotic. It's like the 24/7 news cycle has not produced, I think, smarter, better informed people. It's probably reinforced some degree of laziness and produced an echo chamber. And money has just complicated it even more so, to the point where you hesitate to turn on, any kind of media now because.
Can the court fix that?
Well, theoretically, the court could fix it. It won't, but it could theoretically. The court as composed now won't touch it.
A quick footnote, the decision that said money is speech actually goes back at least to 1976 in the Berger Court, a case called Buckley versus Vallejo, where the court sort of said you can't limit how much candidates spend because you're effectively limiting their campaign activities. I think the analogy they used is like telling you, you can drive a car as long as you want on a single tank of gas. Well, that's not true. I mean, you can drive until the gas runs out. The decision that Michael's referencing expands that, though, dramatically by allowing what was previously not allowed, corporations from spending from their own coffers to advocate, which previously was disallowed. But I think Michael's right that that is a case of a decision that it has had considerable consequences.
I mean, I would just add that the court has the ability to, change the interpretation of the Constitution. They have the ability to overturn the various precedents that they have rendered in the past. The question is, are they going to do it? The answer to that question is no, they will not do it. Because it's kind of baked into the ideology and the belief that money equates to speech, right? And if campaign contributions equate to speech as enumerated in the First Amendment, then, so long as we believe that, then we're going to keep on having money essentially taking over American politics. And it's been that way really since the Buckley versus Vallejo decision back in 1974.
I think we have a lady in the jean jacket, and then I feel like I'm neglecting this side of the room. So y'all get ready.
Thank you. I just want to follow up with some of the things that were said earlier. And I'm going to paraphrase George Washington here for a minute, where he says in his farewell address that factions may become potent engines by which cunning, ambitious, and unprincipled men to subvert the power of the people and usurp for themselves the reins of government. And so when we talk about this idea of citizens united, right, and the idea that the people are their power is being usurped because their speech is not equal anymore because of big corporations, multinational corporations, right? And so my question becomes more about like what was said earlier regarding that the court has become more powerful and less accountable. And so what can be done about that? And are there examples in other countries? We were supposed to have a free and independent or an independent judiciary. It is not so independent given the political status that has occurred and the power that has been usurped. What are the options to hold the court more accountable? And again, are there other examples in other countries?
Yeah, I can start. So for me, I think the most straightforward, maybe straightforward is not the correct word, because what I'm thinking about here is very difficult to actually do or achieve. There has to be a constitutional amendment that changes the structure of the court, right? A lot of people, a lot of citizens have talked about the fact that we need term limits in the U.S. Supreme Court. But what they tend to forget is that the Constitution in Article 3 gives Supreme Court justices lifetime tenure. And if you're going to give them term limits, you have to have a constitutional amendment to change that. And that's one of the most difficult things to actually have done in this country, right? The nation is over 200 years old, we only have 27 amendments to the Constitution. It's very difficult to achieve that. So
I'm going to come at this at a slightly different angle. Without any doubt, I think the single most important right people have is the right to vote. That also may help explain why there's so much effort to regulate it, to restrict it, to constrain it, to suppress it. How do we, and it's how we respond to that, which is the measure of who we are as a people. I think one of the things we've gotten away from, and talking about the court sometimes will lead us down that wrong path, is thinking we don't have power. And I think it is, so Kevin talked about the presidential immunity case, a decision I think is really bad. That'll surprise you. But more importantly, I think one of the things that is kind of hidden in that decision is that if you pick somebody who has respect for the law, you don't have to worry about the bad consequences of a decision like that. And so depending on how you vote, depending on the people you elect, that's going to make the biggest difference. The people you send to the state legislature, the people you send to Congress, the people you elect as president, that says a lot about who we are. And that's how we can control the process. So if you're concerned about big money and bad things, in a sense, corrupting public discourse, then you vote for the forces that would be against that. And then you try and support them. I don't think there's any other way around it. I think it's too simple, too neat to think, oh, if we just had this statute or this constitutional decision, that would solve it. That's just too neat. And one reason why it's too neat is because, frankly, people know how to get around these things. And so, but there's one thing they can't get around, and that is when people get together and say, no, this is how we're going to vote, and this is what we're going to stand for. And I think that's hard for any president to ignore.
I'll just say quickly to your question about what could we do. What we could do, but we won't, is we could follow a path of some other nations. So Germany, for example, has one of the most admired courts in the world. They have a kind of splinter off court that just hears constitutional questions. Its closest thing is, if you remember your American government classes, the Supreme Court was considered as a possible council of revision, which was basically giving the court a veto before legislation went into effect. And so Germany has a court which only hears constitutional questions, and it can stop legislation before it goes into effect. And also, my German friends would know better than I do, but members of the Bundesrat and the Bundestag can actually refer cases to the Constitution. So it's much more academic. So we do it a way which we've become accustomed to and works pretty well, but it's by no means the only way. Other nations have other mechanisms that seem to work well for them too. I don't know what would happen if we had that here, but it's kind of interesting thought experiment.
And to add on to what Kevin is saying, Germany, among other countries, they have a judiciary that's actually trained as a judiciary. In other words, people actually, they're not like partisans out in the world doing whatever they're doing, and then they become judges. No, this is a path. This is a career path they've chosen. So in a sense, they kind of work their way through that system. And I think as a result, you don't hear the kind of response and reactions to those courts that we get here. And I think one reason why is because those courts basically are trying to be technically sound. Mm-hmm. I'd be relieved if we had a court that could be technically sound. I won't go off on too much of a rant here, but I think it is inexcusable when you have a Supreme Court say in a case that dealt with a coach, a football coach was praying after the game. And the Supreme Court says, well, it was not a big crowd and it was not in the center of the field. If you read the record, as any good lawyer ought to do it, if you read the record, there's a photo of the prayer in the middle of the field. Now, we've got a life tenured justice who could care less about that kind of fabrication, but that, in my opinion, is inexcusable for any judge. Well, there's a way to hold the politician accountable.
We have a question online, and then I've been promised that we're going to hit this side of the room, but I promise we'll get to you eventually, James.
Okay, this person asks, did legal precedents used to have more staying power?
I think the short answer is yes, but it gets complicated. Because, and I'll go right to the bottom line. I think what's happening is we have more and more precedents out there, and as a result, we don't see formal rulings as much as decisions that are rendered that narrow and reconstruct prior decisions. So I think a lot of the action in constitutional law has to do with reinterpreting precedent. And an overruling is just the tip of a very large iceberg. Overrulings are not up in terms of numbers, but I think what is happening is also something fairly common with the Supreme Court, and that is they're going back and kind of almost rewriting prior decisions, which is their discretion. They have this power to do that, and reconstructing them. And that's the thing. It's not a sexy thing. It's hard for the public to follow that. But I think that's what's a lot of that is happening.
Can I just say really quickly, just that about the importance of precedent? Michael said that there's so much more precedent. There's a hell of a lot of precedent that is available to anybody that wants to make an argument on any issue. It's child's play to base, I'm serious. You can base an argument in the Supreme Court on any issue on either side and find precedent that plausibly backs you up. If you don't believe me, look at the briefs that are filed in the cases. Both of them are supposed to file and cite their authorities. And both sides have lots of precedent that they trot out to say, well, it's obvious given all these prior decisions how you should make that case. And so I think it's important, as Michael says, is that there's so many choices available, it's hard to say that there is a single precedent that guides all subsequent litigation.
Okay, Miriam.
I'm curious why the Supreme Court takes any cases that they then dismiss due to standing. Why can't they figure that out even before they put it on their docket?
So I'll just, so standing refers to having, what I usually say is the legal right to complain. Do you have the right to go to court? So you care about something, but just caring doesn't give you the right to go to court. And oftentimes those issues are not clear, and they get litigated in the lower courts. And so by the time they get to the Supreme Court, sometimes the question is, because it's been raised below, does this litigant have the right to be here? And so I think the rules are reasonably clear, and by that I mean I could explain them to somebody else. It is an issue of law just like any other issue of law, and sometimes it's not clear what the correct answer is.
Well, it could well be that one of the issues in the case is standing. So you want to have the arguments on that, and you want to think it through. I think what is less excusable is when, and we've seen this a couple times, when the court gets a case, and it's happened a couple times in the last term or so, they get a case and they realize by the time they're arguing and everything else, oh, this is not really what we thought it was going to be. Again, inexcusable. And then there's a whole thing that arises because of what it's called the shadow docket. The shadow docket is something that people didn't used to know about, which, by the way, gives you an idea how unaccountable the court is. But the shadow docket essentially has to do with those cases that are moving really fast and where there's some kind of action that's requested in the case, and the justice decide to give it without briefing it, without putting it through oral argument. Yes. Steve Loddick has got a great book out called The Shadow Docket. And so it's a real big problem because for lazy justices, you can see what I think of them, it's a great way to deal with cases they don't want to have go through full oral argument. Let's just resolve this stuff without going through the full briefing. And by the way, that just makes the court less accountable. you can see I'm a very big champion.
So you said that one of our most important powers is the power to vote, and that we should vote thinking about what sort of nominations for the Supreme Court our next president will make. So my question is, how many open seats on the court do you expect in the next 4 years, the next 8 years?
2.5.
Yeah,
The historical average is a president should have 2 per presidential term. So if you just guessed, you would say.
Based on the current composition, age, time of service.
yeah.
I think right now, I mean, it's a good question. The difficulty is that whoever gets elected will make a difference as to who will be willing to stay or who might step down. For example, if Mr. Trump gets reelected, Clarence Thomas might think, okay, this is a good time for me to step down. Kamala Harris gets elected, Clarence Thomas says, I think I'm going to bring a lunch. I'm not going anywhere. So I think, and that's the calculation some justices will make. However, I think President Obama's appointees and President Biden's one appointee are relatively young and would not be disposed to be stepping down at all, except I've heard Justice Sotomayor has some health problems. I'm not sure they're serious at all, but some people talk about that. And that may or may not persuade her, if Harris gets elected, for example, to step down. I think Justice Sotomayor is loving what she's doing. She really takes great pride in it. I think she works really hard. She wants to be there. So if she were to leave, it's not because I think it would be a regretful decision.
Yeah, but I also think that regardless of who wins the election, it's not really going to change the ideological complexion of the court in terms of, which direction would have a majority. Because, I mean, there are 6 conservative justices on the court right now. The next president might not have any nomination to make. That's a very real possibility.
So let's get to a trivia question. There are only two presidents who served a full term who didn't have a single Supreme Court appointment in that term. I was going to ask you. Jimmy Carter's one.
Jimmy Carter is one.
The other was Franklin D. Roosevelt in his first term. Well, believe me, he was not happy about that.
Oh yeah, I'm gonna walk over to James. While I'm doing that, we never got to hear any of your questions, Ellie. I wondered if you had any questions as well. Just pointing that out. But I'm gonna talk to James real quick.
I have one to wrap us up.
Okay, great. Love that.
So look, I think it was Michael, you mentioned, I think in Germany that judges are trained and it got me thinking about Frank Murphy. Frank Murphy was the trial judge in the case of Ossian Sweet in Detroit 100 years ago, 1925. Years later, he goes on, he's appointed to the U.S. Supreme Court. And I mentioned his name and Charles Evans Hughes, and I mentioned both of them because I went through law school and a practicing lawyer never really heard about them. And they were, I think, excellent justices. Why is it that they're so unknown? I mean, I think.
It's a good question. I think that, so we're talking about Frank Murphy, whom Franklin D. Roosevelt appointed, and Charles Evans Hughes was appointed twice. And so each was a very, very accomplished public servant before they ever got in the Supreme Court. I think in Murphy's case, he was not there long, and I think he was not as much of a leader. So I think he found himself dissenting or not being as influential as some of the other justices. Roosevelt appointed people, all of whom had pretty big egos. So it was sometimes the Roosevelt court was referred to 9 scorpions in the bottle. So and I think it was hard for Murphy to break out of that. You had great people like Robert Jackson Felix Frankfurter, Hugo Black, just to mention a few. I think Charles Evans Hughes is one of the great Chief Justices of all time. I think he's vastly underrated. He had been governor of New York for at least 2 terms when he was appointed as Associate Justice. Then he stepped down to run for president. He lost. But after that, he then became Secretary of State and continued his public service and eventually became Chief Justice and was, I think, by any metric, really great. But one of the things that made Hughes great is he was somebody who was very careful about, he was not showy. He was very meticulous and careful about what he would write. So it wasn't the most lyrical thing you ever read, but it would be sound. And he was also very influential in helping other justices sort of position themselves. Hugo Black, by the way, as a senator, had voted against Charles Evans Hughes when he first came up as a nominee. Later, Black said, as a justice, nobody taught me more about what to do here than Hughes. Sorry.
I think we have a time
That's
for
good.
like 1 or 2. We have one over here.
Yeah, Kevin made the observation that often the Supreme Court kind of gets on board after states and others have already adopted laws and finally it all gets solidified at the Supreme Court, and that's kind of reassuring in a way that the Supreme Court moves with the times. Not quickly, but eventually gets on board. But when I think about that in terms of 2 issues that have been raised tonight, which is the Second Amendment, the will-regulated part, and then the overturning of Roe versus Wade, that 2 issues where, as far as I understand it, there's overwhelming public support, and yet the Supreme Court has gone the other way. First, is my observation correct? Is it an anomaly? And is it something we should be concerned about?
So your interpretation is correct, and I never said it applied to 100% of the cases. I just said we should look at more broadly than simply saying they overturned the constitutional right to abortion. That means the court is uncontrolled, doing whatever it wants in all issues, and it's affecting my life. It does do exactly what you suggested, but I would say I'm not sure that we should base our evaluation of the court as a whole and the impact of its decisions based on a particular decision that happens to be unpopular.
And I think they're different patterns. So if you're talking about issues that are not quite as politically salient, then those issues, it might be issues in which the court will look at how lower courts have dealt with it, maybe learn from that and try and build on that. But when you talk about abortion, everybody's watching.
Yeah.
And so that just went right to the front of the line and got overruled. No hesitancy there. So if it's an issue that pretty much everybody knows the court wants to reach, the court's not going to let anything stop it. And the court will get to it, regardless of what other courts have done or said. Maybe.
If the Democrats win the White House and the Senate, and they're able to expand the court to try to balance things out, what do you think the political ramifications will be?
I'm sorry, go ahead.
Yeah, that's a very good question. I think when Biden first came into office, he had a Democratic Senate, and he was actually under a great deal of pressure, given what happened to Merrick Garland in the previous administration when Obama had appointed or nominated Merrick Garland, but he never even got a hearing in the United States Senate. A lot of people were upset that if the Democrats have an opportunity to put more justices on the U.S. Supreme Court, they should take up the opportunity. And so Biden came under a great deal of pressure to actually introduce legislation to do just that. But I think he was counseled by some individuals, including Justice Stephen Breyer, because Stephen Breyer was not in favor of that idea at all before he retired. But I think, I mean, if, I sort of feel that if the shoe were on the other side, I think a Republican president might have done that. I mean, I don't know, because obviously it did not happen that way. But it just seems to me that when the Supreme Court is right now this institution, I think I kind of differ from Michael and Kevin in the sense that I actually think the Supreme Court is a very powerful institution.
So do I. I do.
But I kind of understand, I understand their position in the sense that if you look at the totality of the cases that the Supreme Court has decided, it has decided, justices have decided a lot of cases that don't have very meaningful impact on the daily lives of Americans. That I get. But as the gentleman back there mentioned, the court will sometimes decide one case that really has a huge effect, generations after generations effect on how Americans live their lives, right? So, but I mean, those are two ways in which you can actually understand what kind of impact the Supreme Court is having.
So I'm going to try and end on a partisan point, which is probably a very bad idea. I think for Republicans, and I have a lot of friends on that side of the aisle, work with them a lot over the years, there is no issue more important than the Supreme Court. It's the top, if you had their top 10 most important issues, they would all be Supreme Court. And so that explains Garland. There's just nothing more important to them than reshaping the court and getting it on the right path. That is not true for Democrats. Different theories as to why that might be the case. One theory is that, well, Democrats just have more of an agenda. And so the court might be one thing they care about, but they care about other things like healthcare and other things. And you can't spend your political coinage on everything. You've got to figure out, okay, what can I get done today and so on. But I think that may help explain why the battles to some extent look the way they do. Republicans will fight to the death over these things. I'm not entirely sure Democrats will. And I'm not saying that's good or bad. That's just the way it is. But what it also means is that whatever happens in this next election, the divide that exists in the Senate isn't going away. And when that next vacancy happens, I can promise you it's going to be thermonuclear war. Because one side thinks that's the most important issue in the world. The other side cares about it too. And so it's going to be, and the composition of the Senate, of course, will be shaped by what happens this fall.
Build my bomb shelter now.
Good. I was big enough.
Could I just add to the last point of your question? I'm always keep saying, think about the context, think about the larger issue. Before the court overruled Roe and Dobbs, do you know how many legal abortions there were in the United States? The same number that there were before 1973. I mean, the number of abortions went up after 1973, and then they started to decline rather rapidly. So we have about as many abortions today as we did before Roe. Why has it gone down? Because it's so easy not to get pregnant now. The availability of various methods of contraception. That's important to think about, I think.
All right.
We have one last question in the back row.
We're at time, but I wondered if Ellie wanted to ask her last question really quickly.
Sure. Apologies to anyone that we did not get to, but we don't want to keep everyone too long. So just as a way to kind of wrap up and thinking about our topic for the evening, what we need to know about the Supreme Court, one of the things that we've talked a lot about is the difference between perception and reality when it comes to the Supreme Court. We have certain ideas about it, but those don't always reflect the reality. So I was wondering if, very briefly, y'all would talk about how do we, as the public, stay informed about the Supreme Court? How do we know what's good information about it? Thinking about how we use our vote in November.
A few years ago, the Supreme Court had invited a group of high school students from California to come to the Supreme Court and talk about the justices. And the topic of conversation during that particular meeting was about judicial independence. And Justice Stephen Breyer, who just recently left the court, was quite emphatic in pointing out that it is really important for citizens to know what courts do, to know what justices do, because it's only by knowing what Supreme Court justices do that you would actually give credence to the decisions that they make, right? And so in terms, so I think I would sort of echo what Justice Breyer was telling those high school students. The people need to gain a deeper understanding. And I think forums like this are quite useful and helpful to citizens to actually understand what the Supreme Court is up to, some of the difficulties that the justices have to go through to actually decide these really monumental, difficult cases. As Kevin mentioned early on, the court does not take easy cases. Okay, it's usually those cases where there is no clear answer that the justices would typically take and try to resolve. And so I think it is very important for citizens to take some time to learn about the justices, learn about what sort of issues are coming to the court, right? There are 2 times during the year in which you hear a great deal about the Supreme Court. During the first Monday in October is when the term of the court begins, the very first Monday in the month of October. So you will always hear lots and lots of media discussions about the kinds of cases that are going up to the Supreme Court. And then during the summer is the second time that you hear a lot about the Supreme Court, when the justices are issuing their decisions for the term, right? So those are 2 times in which citizens should be paying attention to what is actually happening in the Supreme Court and get better informed about what is going on.
I would certainly echo that. It's hard. I'm going to suggest a couple places that might be reliable for information about the Supreme Court. One is NPR. And I think, generally speaking, they do a pretty good job of trying to explain things. They've got experts to come in and from a variety of different views, and they're pretty thorough. The second place, and I confess I'm associated with it, so it's the unfortunate thing, is the National Constitution Center in Philadelphia. I'm a scholar in residence there, but the reason I mention it is because it's the only place in the country that is required by law to not to be partisan in Constitution.
The time is now 7:15. The library will be closing in 10 minutes at 8 o'clock. The time is now 7:50. We will be closing in 10 minutes at 8 o'clock.
Yeah, so the National Constitution Center has a website, and on that website is something called the Interactive Constitution. It's all free. Also, the National Constitution Center worked with C-SPAN to put together 2 seasons of documentaries on big Supreme Court cases. So those documentaries are terrific. And one thing about the Interactive Constitution also is the essays that were written, and there's an essay for every part of the Constitution, was typically written by 2 people of different views. They'd come together, write a common essay, and then they would each write a separate essay explaining their differences. But I think the National Constitution Center is a very reliable place to go. It'll give you a fair, even-handed overview and introduction to whatever you're interested in. They also are very on top of the news. So I think I would suggest that.
I just have one quick suggestion. First, I'll say you all are so kind and gracious. We're way over. I can tell you, you probably have the same experience. In my classes, if I'm 1 minute over, I mean, the laptops start getting slapped. People are making a rustle. You know you've got to stop because they're, by God, we have to stop right on time. One thing I would say is a resource that maybe is a little obscure is something called SCOTUS blog. SCOTUS blog is terrific. I think of it as nonpartisan, and you can sign up for their newsletter so that you can get a daily email of kind of news articles that are touching upon recent Supreme Court issues. And they maintain a terrific website. You can look up any case. They have very nice analysis on cases that are forthcoming. I learned a lot from looking at it. I think you'd enjoy it.
All right.
Yes.
Thank y'all so much for coming. Let's have a big hand for all of our panelists.
Thank you.
And for Carolina Public Humanities.